Tax benefits of a trust in California can save your family a real amount of money, or cost you just as much if nobody explains this to you in time. If you've just inherited a home, or you're serving as a trustee for a parent or a loved one, this is one of the most important things you'll learn this year. So let's get right into it. A trust done right does one thing for taxes that matters more than almost anything. It helps preserve what's called a stepped-up basis. A stepped-up basis on real estate. Here's what that means in plain English. When your parent bought their home decades ago, they may have paid a small fraction of what it's worth today. If you inherit that home properly, the tax basis steps up to today's value. That means if you sell the home soon after, you owe little or nothing in capital gains tax. A trust, when it's stepped up and funded correctly, keeps that step up intact and keeps the home out of probate court, where delays and errors can put that benefit at risk. Before we go further, we want to be direct about something. Attorneys handle the law. Accountants handle the numbers. We manage what actually goes wrong in real life: property, people, timelines, and conflict. That's different from a DIY trust website, different from a court clerk who only perform administrative tasks. They cannot provide legal advice or draft documents. But for local help, visit the Orange County Superior Court Self-Help Center for form packets. We sit in the middle of it all, coordinating the pieces so nothing falls through the cracks. Now, a trust doesn't just protect the tax basis, it also keeps the property out of the public probate process entirely, which matters more than people expect. Probate in California is slow. It's public, and every month the home sits in limbo is a month of property tax exposure, insurance risk, and maintenance costs piling up. A trust lets a successor trustee step in immediately without waiting for court approval, and that speed alone protects the value of the estate. If this is something you're facing right now, an inherited home, a trust you don't fully understand, or a probate process that feels overwhelming, subscribe for clear guidance and know you don't have to figure this out alone. Let me share this story with you. Two sisters lost their mother within the same year in two different Orange County families under very similar circumstances. Both mothers owned homes worth close to the same amount. Both had lived in these homes for over 30 years. In one family, the mother had set up a living trust years earlier and had actually funded it, meaning the house title was moved into the trust's name while she was alive. In the other family, the mother had a will but no trust, and the home was still titled in her own name when she passed. The family with the funded trust moved quickly. Within a matter of weeks, the successor trustee had access to the home, could pay the property taxes and insurance without interruption, and sold the house within a few months. Because the basis had stepped up to the date of death value and the sale happened close to that date, the family owned almost nothing in capital gains tax. The proceeds were split clearly among the siblings. The other family wasn't so fortunate. Because there was no trust, the home had to go through probate court. That process took the better part of a year. During that time, the sibling disagreed about whether to sell or keep the home. A family member who had been living there didn't want to leave, and the house sat vacant for months, which created its own maintenance and insurance headaches. By the time the sale finally closed, the market had shifted, repairs were needed, and legal fees had chipped away at what should have gone to the family. The tax basis was technically still stepped up, but the delays, the disputes, and the cost of probate ate into the benefits before anyone saw a dollar. Same tax law, same starting point, completely different outcomes, because one family had a properly funded trust and the other didn't. Now, we want to be honest with you, because a trust isn't automatically the right answer for every family. It isn't free of downsides. Setting one up costs money up front, often more than a simple will. A trust only protects what's actually been retitled into it. So an unfunded trust, one where the home was never legally moved into the trust name, offers almost none of these benefits and can even create confusion and who's really in charge. Trust also required someone to serve as a trustee, and if that person isn't organized or isn't willing to communicate with the rest of the family, disputes can happen inside a trust just as easily as they can in probate. None of these are reasons to avoid a trust, but they are reasons to make sure that yours is set up properly and kept up to date. Here's the mistake we see more than any other. A family comes to us with a beautifully, properly drafted trust document, and they assume the work is done. But a trust is only a set of instructions until the actual property is moved into it. That step is called funding the trust, and it means the deed to the house has to be retitled from the parent's name into the name of the trust. The same goes for bank accounts and investment accounts. Each one has to be retitled or have the trust named as the beneficiary. If that step gets skipped, and it gets skipped more often than you'd think, the trust document exists, but the house is still legally in the parent's individual name when they pass. That single misstep can send the property right back into the probate court, the exact outcome the trust was created to avoid. So if you're not sure whether a parent's trust was ever funded, that is the first thing worth checking, often through a simple deed search at the county recorder's office, before you assume everything is already handled. So what is the actual purpose of a trust account? At its core, a trust account is simply a legal container that holds property and assets on behalf of the people who will eventually receive them. The trustee manages what's inside: real estate, bank accounts, investments, according to the instructions the trust document lays out. Done correctly, it protects the tax basis. It keeps the family out of court, and it gives someone the legal authority to act quickly when time and money are both on the line. That is the entire purpose in a single sentence: protection, speed, and clarity for the people left behind. If you're a trustee or an heir right now wondering whether the state you're dealing with has a properly funded trust, or wondering what your next right step actually is, that's exactly where we come in. This is not legal or tax advice. This is spoken in plain English for education, so you can ask better questions and avoid costly mistakes. If you need help with estate clean-out, property maintenance, a locksmith, or a referral for a trusted CPA or estate attorney, reach out. I've got trusted resources ready to help you through every part of this.